So let's say that it's for spousal support. And we're trying to figure out this default clause. So what would a default clause example be? What is an example that you
Sure.
can?
So that's where family law can really look like civil law in a lot of ways. When it's really just party A owes party B money,
Yep. Mhm.
what happens if party B defaults,
Yeah.
right?
Yeah.
Has a late payment or short payment or doesn't pay at all.
Yeah.
So family law and civil law can, especially when it comes to spousal support, can look very similar.
Ah.
Oftentimes you will see a default provision. So it says in the case of default,
Yeah.
the other person will notify. So the recipient will notify the payor, hey,
Mhm.
there's a default payment.
Yeah.
There's sometimes a grace period of 3 days or 4 days or 5 days or 30 days. On the civil side, sometimes you'll see 30, 60, 90 days are very common on the civil side.
Okay. Yeah.
But on the family law side, you'll see shorter time periods
Right.
for delay.
Right.
But they'll give them a grace period and they'll say,
Yeah.
hey, please have my payment by 5 days or 7 days. And then if there's still a default,
Mhm.
there's typically interest added. So
Ah.
that's the piece,
Right.
right?
Right. Right.
And then typically the clause will say that the person can, in so many words, it'll say the person can bypass mediation and can enforce that part in court, and that the defaulter will not only pay what is owed to the principal plus the interest, but also the other person's court fees,
Ah. Right.
the
Right. Right.
expenses that they have to incur in order to, go ahead and get their money back. The problem is when the person really needs the money
Yes.
and the court system is backed up,
Yes.
right?
Yes.
Also, too, the secondary problem with that, and something we tell our clients all the time, is you can't get blood out of a stone,
Yeah.
right? If
Yeah.
someone's gone bankrupt or if someone has no money,
Right.
right, then that other person's going to be paid, not going to be paid.
Yeah.
That's why you want to avoid, in the larger circumstance, you want to avoid these kitchen sink deals where parties come to agreement by themselves, they write something out by themselves, and then 10 years later, 5 years later, there's issues down the road. You want to make sure you're working with a legal professional, whether it's a mediator, two lawyers, one lawyer at the very least, to
Mm.
that default clause so that the person who is supposed to be in receipt of spousal support does not have a long lag time.
Good point.
They're supposed to get paid and when they can enforce it.
It's also interesting. I wanted to go back to something you said earlier, which was very interesting because you said that this is that part about the FRO, and they would enforce default to separation agreements. So does that mean that if you have a separation agreement, you don't have to go to court first and then go to the FRO? You can just go to FRO directly.
Let me clarify. So for
Yeah.
child support, especially child support, although sometimes FRO can enforce spousal support when child support's already being paid monthly.
Okay.
But typically for child support, that's where family law differs from civil law. In
Hmm.
civil law, it's just if Eva owes Heather and Eva doesn't pay, then it depends on the amount. That's dependent on the amount that dictates what court you go to,
That's
whether it's
true.
small claims court or not, right?
Right.
Um, in family law, it's different. It depends on the type of payment in a lot of ways. So for the Family Responsibility Office, they have jurisdiction over child support enforcement. So instead of taking your co-parent to small claims court, right, for lack of a better term, or
Right.
to court for child support, you would contact the Family Responsibility Office. That it's set up that way to keep people out of court because, as you can imagine, there are a lot of people who are in default of child support.
Right.
Right? It would completely overrun our court system.
Right.
Court overheard every late payment of child support. So the Family Responsibility Office has legislated powers. The law gives them powers to enforce without a court order because they can use a separation agreement. So if you have a separation agreement, you can enforce it by essentially having a FRO clause in the agreement, then sending FRO a copy. And then FRO can enforce it that way. So they have a lot of powers that they can do. They can contact the child support payor, and they can set up direct withdrawal, which is very common. They can set up the employer of the payor and take money directly from the employer. So before it's paid out, right, before the employer pays out the employee, they would pay the child support to FRO, and then they give the balance to the employee. They can take money from an RRSP. They can also suspend a license, so they have some punishment, right, too. They can suspend a license. They can suspend, they can put a flag on your passport. So the larger the arrears of child support, the more FRO can do.
What about equalization payments and stuff like that? They don't do that, right? And spousal support, you said, is only if there's already child support, sort of.
Sometimes I've seen if there's monthly spousal support, if child support's already being paid, but generally no. FRO is really meant for child support.
Which makes sense. Yeah, the children come first. Okay, now that's all my questions. Is there anything else you want to add? Any tips you want to add for people?
Laura, do you want to talk a bit about just the small scenario where the separation agreement just isn't working for families anymore and what they did?
I think this is where the dispute resolution clauses come into play, and they're very useful to parents. Let me put it this way. When you, and I'm going back to what Eva had mentioned earlier, it's how you got to your agreement. Because generally, when you get to an agreement through courts and imposed on you, and there's resentment, and there's not much detail, because the court is not going to take the time to create the detail that your family needs. Right? So there's not much detail in terms of language, expectation, dispute resolution clauses. It's just an order of, Monday to Friday is mom, whatever, Friday to Sunday is dad, and then there's joint decision making, and there's not much depth to the court order. Now, so that's one piece, which that piece, it's thin. There's going to be a lot of room for misinterpretation, for gaps, for ongoing default, for ongoing, reflective of maybe I have not default, I have no idea that I was defaulting, I didn't think that way, things like that. So not necessarily a nefarious default. I'm just saying, they just accidental, they didn't know. So there's a lot of gaps there. When you get to an agreement through either lawyer-led negotiation or a collaborative process like a mediation, then you have the ability to build the density of the clauses that you need to address all of these concerns, or most of the concerns. So when you have the depth of the clauses, it's going to minimize your ability to default, because it's there. You thought about this. You put the remedies in place, and then you act it out. But if an agreement doesn't work well for someone, which happens as the children grow, for example, if a relationship still needs to be kept for the co-parent, things do change. New parents come into play. New residences, relocation is a big thing, school change, private to public school, things like that. So there are components that can be foreseen into a parenting arrangement or co-parenting relationship that we know from this moment, from today, we know that they may surface as the relationship progresses. So we take care of them in the agreement now. So we say, if let's say little Johnny's starts daycare in March of 2025, we have to review his arrangement, because the parenting arrangement today, it's no longer going to be a viable option for him in next time when he starts daycare. Then you plug that into the agreement. You calculate that review. You say, in March of whatever, we're going to have a review, and then everybody sort of has an idea that there are certain elements that may disrupt the agreement as it stands today, but we have a way to address it in the future. Other things that families have in the agreement are those clauses of you return to mediation. So return to mediation is a given. You come back, you talk about, the nuances, the changes, what's happening, and then we amend the agreement. So we either change the schedule or we add or subtract certain things, right? It's really trying to figure out what works.
No,
When
right.
Yeah.
I have a question. When you come up with an agreement, you don't have to file it or register it with the court or with the Family Responsibility Office, right? You just keep your agreement, right? Like for people who just have freshly finished with the mediation. I mean, there's no reason to like run off to court or
No.
There is no, they don't have to. They keep it. They sign it and they keep it and they refer to it if there's an issue. Hopefully, in many respects, in many families, in fact, they find ways to grow into their co-parenting arrangement that they don't have to reference back to the agreement all the time. They would only if there's an issue, right? So, but I think what the devil lies it's in the details. The more detail you're able to put into the agreement today, the better the easier is going to be, and the less the risk of defaulting. And I wanted to some of the tips that I think families can include or can wrap their minds around. When they design an agreement, one is, what's my dispute resolution clause? What happens if one or both do not follow, no longer want to follow? Because there are different dispute resolution clause or default clauses that you can apply, as you can see, to money things, to child support, than to parenting issues. So you want to make sure that you apply the right language to the right circumstance. So if there is a money issue with child support, you have a clause that deals with notice, with FRO, with whatever next steps, right? Paying for legal fees, things like that. If you have an issue with parenting, then you may want to contemplate adding a parenting coordinator or someone who may have the authority or the jurisdiction in that dispute resolution mechanism to make a decision in case the two of you cannot come to a decision, right? Other ways that we've seen families really detail certain clauses to avoid any misunderstandings is Section 7 expenses. Extraordinary expenses are absolutely, they can be a nightmare and there's a lot of room for someone to default without really truly believing that they're defaulting or wanting to default. It's because there is a vagueness in their agreement that he simply says, these expenses are to be shared proportionate to income or 50-50, and they're supposed to be on consent. So off you go. So, when off you go, one parent may have a different understanding of what and different ability sometimes, or different belief system or what the children should be enrolled in, what expenses should be, they're valid or invalid. And the other parent may have different ones, right? So as long as you clarify that these are the expenses, and that's really actually FRO can enforce those too, but FRO can enforce Section 7 expenses as long as you clarify what are those amounts. Sometimes we have families who say, okay, well, we're going to share all of them 50-50. But what is all of them, right? And that's the problem. Is it soccer, swimming, ballet, dance, and tuition for private school, right? or is it just swimming, and is it a cap, right? So we have families who say, 1 second, I want my children to be involved in all of these activities or these opportunities. That's great. At what cost? Can I afford it? So now they may not default because they wish to default. They may default because they can't financially sustain that. But if you foresee that, you can add it into the agreement. We've had creative families, creative options that said, we share 50-50 these expenses up to a cap of $3,000 a year per child. Or they say, I choose 2 activities and we pay, you choose 2 activities and we pay, or we 50-50. Anything above and beyond my 2 activities, my allotted, I pay for it, my responsibility. Anything above that, you pay for it, your responsibility. So they can be really creative and they can really minimize at that point. Now you can really enforce that too, right? So it allows for the past to be enforceable because it's right there in black and white, the amounts, the activities, the cost associated with it.
Yeah.
And then you can also minimize the risk for them to default on it because they've pretty much created this, right, together, and they're comfortable with it.
It just never occurred to me that sometimes, especially if you have parties who come like drafting their own, let's say, separation agreement that could be vague, like you said, and then they take it to the FRO, and the FRO might actually say, but wait a second, what does this mean?
Right. FRO may say, yes, I understand. Section 7, yes, I understand. Daycare, yes, but soccer, things like that, they may be listed as
Yeah.
part of the expenses that to be shared. But what's the cost? FRO is not going to get into, how did you ask for consent? Is there, they're not, they don't even have the capacity to do that, right? So if you feel that there's an issue or there may be an issue, and even if you don't think there's going to be an issue, but you want to sort of protect the co-parenting relationship from disruption and conflict, then you may want to be very careful how you list this and how, associate a cost to it, so that if something happens, you're both prepared to take the least destructive action.
That's a good point. You just reminded me that I think it's such a good idea for people to talk to a family mediator or family lawyers, because that they've gone through this many times and they can anticipate what to put in there. Where I think that as lay people, sometimes we don't realize what to look for, like what to include. So, I mean, yeah, because, you're mentioning these things, I'm going, oh yeah, I haven't thought about that. Or, yeah, sounds really good. Thanks so much, Laura. And Eva, do you have any last words before we wrap up?
I think that was great.
Oh, that's great. Well, thank you very much both for coming today. It was really, really important information. And thanks everyone for watching. If you're new to the channel, don't forget to subscribe so you'll stay notified of our upcoming videos. And we'll see you the next time. Bye.
Bye.